welcome to Courts Today by Live Law. Let us start with today's top headlines. The Supreme Court has granted interim bail to Asaram Bapu in the rape case for medical treatment. The Allahabad High Court has dismissed a PIL against motion to impeach Justice Shekhar Yadav over his VHP event speech. The Karnataka government has approached the Supreme Court against bail granted to actor Darshan in Renukaswamy murder case. The Supreme Court has today clarified that there is no cap of 10 years experience on the treasurer's post reserved for women in the Delhi District Bar Association's elections. The Himachal Pradesh High Court has said that sexual assault child victim has no locus to file Quashing plea in the name of saving family's honor. The Telangana High Court has refused to quash an FIR against BRS MLA KT Rama Rao in Formula E race scam case. And the Delhi High Court has rejected the plea challenging CAT 2024 results. This is your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before moving ahead, let me tell you, Live Law Academy is offering a value-packed opportunity for the aspiring judges out there. The Judicial Service Examinations Preparation Course. This comprehensive online course is designed to help you prepare for your judiciary exams. The classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study material. And all of this comes at a very affordable fee. So if you are gearing up for the judiciary exams, this is a must-check opportunity for you. Enroll today and get 20% scholarship. Remember, only 5 days are remaining to avail the scholarship. You can check all details at www.livelawacademy.com. Starting with an update from the Supreme Court, which today granted interim bail till 31st March to self-styled godman Asaram Bapu, who is serving a life sentence in a rape case following conviction by a Gujarat court. Senior advocate Devdutt Kamath, along with advocates Rajesh Gulab Inamdar and Shashwat Anand, argued for Asaram Bapu, focusing on both the merits of the case and his medical condition. They contended that the conviction relied only on prosecutrix testimony without supporting evidence and highlighted inconsistencies in the prosecution's case. However, the court chose not to examine the merits and limited its review to Asaram's health, leading to the dismissal of the SLP. On the medical grounds, senior advocate Kamath highlighted Asaram's advanced stage, a history of heart attacks and other severe comorbidities. He urged for bail to allow him access to urgent medical care outside of jail. On the other hand, Solicitor General Tushar Mehta, appearing for the state of Gujarat, opposed the plea, emphasizing the gravity of Asaram's conviction and asserting that adequate medical facilities were available to him in the custody. After weighing the submissions, the bench of Justices M.M. Saundaresh and Rajesh Bindal today granted him medical bail till 31st March, enabling Asaram to undergo necessary treatment. The bench clarified that the relief was granted solely on humanitarian grounds and added a bail condition that Bapu should not meet his followers upon release from the Jodhpur jail, where he is serving a sentence in another rape case. The next update is from the Allahabad High Court, which today dismissed a public interest litigation plea filed against the impeachment motion submitted to the Rajya Sabha Secretary General by 55 MPs seeking impeachment of Justice Shekhar Yadav. This, as you know, was over the speech delivered by him at Prayagraj on 8th December at an event organized by the Vishwa Hindu Parishad. The PIL sought a directive to the chairman of Rajya Sabha to disregard the motion filed by MP Kapil Sibal and 54 other MPs against Justice Shekhar Yadav. It argued that Justice Yadav's remarks were made in his capacity as a Hindu on matters important to Hindus' daily lives. It further stated that the meeting's participants were exclusively Hindus and therefore his comments should not be classified as hate speech as defined in public meetings. But the bench of Justice Ataur Rahman Masoodi and Justice Subhash Vidyarthi dismissed the PIL plea, stating that it was not convinced of its maintainability. During the hearing, Justice Vidyarthi remarked that a PIL is only applicable when it addresses the cause of a vulnerable section of society. In response to this, the petitioner sought to argue that the larger issue was regarding whether judges have the fundamental right to speech and expression. But the court was not impressed with this argument and said that the judge who is being referred to in the PIL is not vulnerable and can approach the court if required. Thus, the court dismissed the PIL. The Karnataka state government has filed a plea before the Supreme Court challenging the order of the Karnataka High Court by which it granted bail to actor Darshan, Pavitra Gowda and other co-accused in the Renukaswamy murder case. The bail was granted last month. As per the charge sheet, Darshan was involved in the killing of his 33-year-old fan over sending obscene messages to actress Pavitra Gowda. Darshan had allegedly got the deceased abducted from Chitradurga and had him tortured for 3 days in a shed in Bengaluru in June last year. The deceased later succumbed to the abuse with his body thrown out in a drain as per the police report. All the accused had moved the High Court seeking bail after the Sessions Court had rejected it. Also, let me tell you, in October, the High Court had released Darshan on interim medical bail to undergo surgery. Moving ahead, in the plea seeking reservation for women lawyers in Delhi bar bodies, the Supreme Court today clarified that the cap of 10 years experience imposed on certain posts directed to be reserved for women lawyers is not applicable to the post of treasurer. If you recall, last month the court had directed reservation of 3 posts for women lawyers in the upcoming Delhi High Court Bar Association elections on an experimental basis. Further, in the district bar associations, it had directed that the post of treasurer plus 30% of other executive committee posts shall stand reserved for women lawyers, including those already reserved for women. Today, the matter was mentioned before a bench of Justices Suryakant and N. Koteshwar Singh. 2 interlocutory applications had been filed seeking clarification of the court's order reserving posts, as certain aspects of the order were being misinterpreted by the returning officer. Considering senior advocate Sonia Mathur's submissions and the urgency involved, the court took the main matter on board and issued the necessary clarification that there is no eligibility condition of 10 years experience prescribed by the court. The Himachal Pradesh High Court has ruled that once a criminal case is initiated, the complainant's role ends and they cannot request to quash a case under the POCSO Act, even to protect the family honor. This case involved a father who filed an FIR against an accused under the POCSO Act. Later, he sought to withdraw it because a compromise had been reached and that the case was affecting his daughter's upcoming engagement. But the court said that the complainant, as the father of the victim, had no right to request the quashing of a serious criminal case to protect the family honor. Justice Virender Singh emphasized that quashing such cases goes against the purpose of the POCSO Act, which is to protect children from sexual offences. The court noted that crimes under the POCSO Act are offences against society and not just individuals. Allowing such cases to be quashed would encourage other offenders to manipulate victims or witnesses into withdrawing cases. Thus, the plea to quash the FIR was dismissed. In another update, the Telangana High Court today refused to quash the FIR lodged against BRS MLA KT Rama Rao over alleged irregularities in the conduct of Formula E race in Hyderabad when BRS was in power. Rao had been booked under provisions of the IPC for criminal breach of trust by public servant and criminal conspiracy, as well as under Prevention of Corruption Act. The prosecution has alleged that when Rama Rao was the Minister for Department of Municipal Administration and Urban Development, he did not take approvals regarding the conducting of the event and that there was a serious flaw in the approvals which was not in accordance with the relevant business rules. Rao had later moved the High Court in plea for quashing of the FIR. On 20th December, the High Court had granted him interim protection from arrest, which was extended by the High Court on 31st December till passing of orders. Rao's counsel argued that the FIR was lodged out of political vendetta and the case of alleged misappropriation was not made out. While challenging his arrest, Rao argued that the agreement for the race was already in place when the government took over as the sponsor after the original sponsor had backed out. Well, after hearing the matter for some time, Justice K. Lakshman refused to quash the FIR against Rao. And lastly, the Delhi High Court has today dismissed a petition challenging the results of the Common Admission Test 2024 or the CAT for admissions to top management institutes. The plea was filed by a candidate who claimed that an incorrect answer to question number 18 in the verbal ability and reading comprehension section had adversely affected his exam results. He sought the annulment of the exam results and requested the appointment of an expert committee to verify the correct answers. The CAT 2024 was conducted on 24th November last year with the provisional answer key released on 3rd December. The candidate had objected to an answer in the provisional key, arguing that it was incorrect. Despite his objection, the final answer key was released without any changes. He contended that his objection was supported by distinguished experts and faculty from various CAT coaching centers. He also argued that IIM Calcutta declared the results on 19th December without addressing his concerns or allowing him time for legal recourse. But finding no grounds to interfere with the exam results, Justice Tara Vitasta rejected the plea. For more information on the cases discussed, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share, and subscribe to our channel.